I want to welcome you to this final topic in today's webinar. This will be entitled Ethics in Florida. My name is Jonathan Walker, and I'll be the moderator for this panel. Just a little background. Many of you know me. I was a defense attorney for a number of years at Conroy Simberg. In 2016, I was appointed by Governor Rick Scott to the Panama City District. I spent about three and a half years over there, and in last July, actually, July 2020, I was able to transfer back to my hometown here in Pensacola, Florida. I am a former prosecutor here in Pensacola. I spent a number of years doing that. I've also worked very briefly as an assistant county attorney in Walton County. Enough about me. At this point in time, I want to go ahead and introduce you to our illustrious panel. Joining me initially, and I'm going to talk about the Honorable Carol Stephenson, who's the Judge of Compensation and Claims in West Palm Beach. A little bit about Judge Stevenson. She began her legal career as a judicial staff attorney for the First District Court of Appeals in Cincinnati in 1981. She is licensed to practice law, now inactive in Ohio. She was admitted to the Florida Bar in 1983, and she initially worked as an associate in a personal injury law firm, as well as for a general practice firm in West Palm Beach. She then practiced as a field litigation counsel for an insurance company in the area of workers' compensation and civil litigation. In May 2017, Governor Scott appointed Judge Stevenson to the West Palm Beach District. She participated on the Workers' Compensation Committee of the Palm Beach Bar Association and the local Friends of 40 Scholarship Fund. Also on the panel today, we're very happy to have the Honorable Ray Holley, Judge of Compensation Claims in Jacksonville, Florida. A little bit about Judge Holley. He graduated from Stetson University. He also served as a legislative assistant in the Florida State Senate. He left that position to manage 2 political campaigns before earning a Master's of Public Administration and a Juris Doctorate in 1997. While attending Stetson Law, Judge Holley interned with 2 United States District Judges, the National Labor Relations Board, and the State Attorney's Office in Clearwater. He was elected twice as vice president of the Student Bar Association while at law school. He was also awarded membership on the Stetson Law Review. Judge Holley was admitted to the bar in 1997 and the Georgia Bar in 2006. He began his legal career as an assistant state attorney, which was followed by working as an in-house counsel for an international logistics corporation. In 2002, Judge Holley joined the law office of Amy Warpinski, who was the field legal office of Liberty Mutual Group. His area of concentration was Florida and Georgia workers' compensation, with a secondary focus on automobile and premises liability. First of all, I want to certainly express my appreciation to the panel for joining me today. And as I indicated earlier, we are going to be talking about ethics in Florida. And in preparing to begin a talk on ethics, I did a little research. I went online and just looking for some quotes that we thought we could use. And the first quote I found was from Albert Einstein. Albert Einstein stated that relativity applies to physics, not ethics. And I found that, and I got to thinking, what exactly does that mean? And in reviewing that in my mind, I said, well, have you ever heard someone say, it's all relative? It's all relative. I got to thinking about that, and that's generally said, in my experience, and certainly with my kids, by someone who's trying to justify some prior actions. And then I got to thinking, well, in the world of ethics, it's really not relative. In this regard, I think Einstein was completely right. Ethics are standalone principles that should not be relative to circumstances, coworkers, or supervisors. I'll try to put that another way. Ethics should not change relative to the conditions at work or at home. What you would do at home and at work should be the same thing from an ethical standpoint. And importantly, in Florida, these ethical principles, these standalone principles for adjusters were codified a number of years ago into a code of ethics, and that is found for your reference at Rule 69B-220, 201, 1 and 2 in the Florida Administrative Code. And importantly, Florida law in Chapter 626 states that an adjuster shall subscribe to the code of ethics specified in these rules. And what that means is that these codes of ethics are absolutely mandatory for adjusters. And to explore a little bit more about what that entails, particularly this Florida administrative rule, I'm going to hand it off to Judge Holley, who's going to talk about some of the subcategories of the ethical rules. Judge Holley?
Okay, I apologize for having to join you by phone. We're having some internet connectivity problems in Jacksonville right now, and but thank goodness for technology, we're able to do that. So I guess what I'd like to do is to have the slide that, let's see, by Martin Luther King, Jr. And it, I guess if Katie, if you'll put that up. The slide says, the time is always right to do what is right. You know, so it goes without saying that when one doesn't do what is right, there are normally repercussions and penalties that come into play. And so I felt like that kind of fit this section quite well, as we're going to review the ethical standards that are found in 69B-220.201, Paren 3, the Florida Administrative Code. And I've been assigned to address the first four of them. But I want to preface this by saying, you know, that in my past life as a defense attorney representing employers and insurance companies, I've met some exceptional and highly ethical adjusters. I learned a lot about this industry from them ethics-wise and how to treat people, and I have no doubt that they'll continue to do so in such an ethical manner. With that being said, there are always some bad apples that fall from the tree, in any industry for that matter. There are also adjusters who are new or who are not up on the code, or sometimes just have a bad day, a week, or a month. But I think I can probably say this from all three of us from the standpoint of saying, please don't construe anything we say for this to mean that we have a negative view of adjusters as a group. That's simply just not true. So some general comments about the ethical standards that we'll be going over. You know, in addition to the potential penalties that can be imposed upon an adjuster's license for ethics violations, there are also some negative practical implications that can come into effect when ethics are being questioned or found to have been violated. That certainly can impact, you know, an adjuster's case. You know, I'm seeing more and more creative arguments being raised by claimants, attorneys during final hearings and evidentiary hearings. I'm going to cover a case that Judge Stevenson was kind enough to find, the Krupke case, where one of these ethical standards even appeared. I've also seen where alleged ethic violations were used in an effort to chip away or tear down adjusters' credibility and reputation. And frankly, I wouldn't be surprised if we didn't see more of this come into play as workers' compensation continues to evolve and become even more specialized. You know, typically there are several moving parts to any trial or evidentiary hearing, at least in my humble opinion. The first is obviously the main issues and defenses, but there's also often, but not always, equity arguments or side skirmishes that go on as well. I call these arguments part of the battle to establish which party has the most unclean hands, or which party has the most clean hands, depending on the circumstances. These arguments are usually only effective when there is a close call or credibility is an issue. Now, a savvy claims attorney can utilize ethics violations to try to make you look bad or paint you in such a way. And although your attorney may object on relevance grounds, you know, if credibility is an issue, it's a good chance, there's a good chance, or it's likely the objection will be overruled. Also, during a deposition that an adjuster is in, a judge is not usually involved, and so it's always after the fact that it's being reviewed. So, on the other side, I guess, if you know your ethical rules and can cite to them, I think it actually could even work in your favor if you're being questioned about something like this in a deposition. I realize that this is not something that's of the norm, but once again, I kind of can see where this eventually will be more in the future. So let's talk about the first four of these ethical standards. The first is no undisclosed financial interest. And what this says, in essence, is an adjuster shall not directly or indirectly steer any claimant needing repairs or other services in connection with a loss to any person with whom the adjuster has an undisclosed financial interest. So some examples that have been provided, I guess one would be what you would consider to be a kickback, for lack of a better way of phrasing it. You know, if an adjuster steers a claimant to someone or some company that will or is reasonably anticipated to provide the adjuster any direct or indirect compensation for the referral or for any resulting business, you know, that is prohibited by the code. Also, another example that's been provided is if an adjuster steers a claimant to a vendor where you or a family member have an ownership share. But under the circumstances, I think one of the key words in the standard is undisclosed. So, you know, if there is a situation where it's known to your upper managers and also to the insured, then potentially, you know, that might still fall within the, you know, it would not be considered an ethical violation. But my guess is that if you were to share that with your upper managers or, you know, the insured, that it probably would not be allowed. So in any event, let's move to the next one on equal treatment. An adjuster is required to treat all claimants equally. An adjuster shall not provide favored treatment to any claimant. An adjuster shall adjust all claims strictly in accordance with the insurance contract. You know, it also goes without saying that an adjuster cannot treat a claimant with less than equal treatment. So, you know, obviously those things that, you know, everyone should be careful about as well. No discrimination on the grounds of gender, race, sexual orientation, religion, etc. You know, even if the claimant just has a crappy personality, you're still held to an ethical standard of treating them the same way you would do any other claimant. And one thing I guess I would point out is the optics of having to explain inconsistent claims handling practices toward a claimant is not where you want to be or have to be in that situation to explain it. So, so this case that Judge Stevenson was kind enough to provide, Krupke versus Perkins Family Restaurant, it's an OJCC opinion from 2010. This ethical standard was actually cited and litigated. The case involved a claimant who made the argument that because of her advanced age, she should have been treated differently and appropriately, basically with special handling in a sense. Interestingly enough, there appears to have been a different, there appears to have been two ethical standards that were being discussed, one of which I don't believe is still in the code, and that is that an elderly advanced age type of person should receive special treatment, which kind of ran in conflict with, you know, everyone should be treated equally. But in this case, fortunately for the employer carrier, there was no evidence that the claimant had been treated any differently as any other claimant, and the argument was rejected by the judge. My main takeaway from this was that this is, you know, it was surprising to me that an adjuster's ethical standard was part of the litigation. It was part of the discussion. So I guess what I would say is this is an example that it can happen, and I wouldn't be surprised if we saw more of it later. All right, so we'll go to the next one then. No action prejudicial to the insured. An adjuster shall not approach investigations, adjustments, and settlements in a manner prejudicial to the insured. So no gratuitous favors to the claimant. Even if you're angry or upset at the insured, you have to objectively adjust the claim. And even if you really like the claimant or feel sorry for the claimant, you still have to objectively adjust the claim. And I guess something that is not really an investigation, adjustment, or settlement is, you know, how I guess an adjuster acts during a final hearing. I do have a quick war story I'll just share with you. This happened 7 or 8 years ago, and an adjuster wanted to attend a final hearing by phone. And this was over the objection of the claim attorney who wanted to call her live to prove his case in chief. So the trial started, and it lasted pretty much all day, and it was 4:45 in the afternoon, and it was time for the adjuster to appear. And this was pre-COVID, so the adjuster was at the claims facility, and no one could find the adjuster. I guess the adjuster had to go home for some reason. So in any event, I normally would just have gone on with the trial and finished it up without the witness. However, the claimant attorney was upset about this being prejudicial to his case, and so he was insisting, and I felt like the fair thing to do was that we would just recess and reconvene the trial the following week, despite the fact that we could have finished it that day. So when we came back for the trial, the adjuster did appear. She did not apologize. She did not seem remorseful in any way, and she was actually angry and put out that she had to testify. And I understand nobody really wants to testify, but you know, I guess I would point to that as a good example of how an action could potentially be prejudicial to the insured and to the insured's case. Now, I'm well trained to keep bias or emotion out of my decisions, but certainly with some judges, this action potentially could have been devastating for the insured. So I just wanted to give that as an example of what that might look like. All right, so I'll move to the next one then, making only truthful or unbiased reports. After the investigation, adjusters are ethically charged to make truthful and unbiased reports of the facts. It's critically important to higher ups and you're insured to know what they are up against, what is the true exposure, and not sugarcoating, because that is never good for anyone trying to make decisions, business decisions on very tough calls. Arguably, I would say that the scourge and burn methodology of denying every benefit and forcing the claimant to litigate everything is potentially an ethics violation that could impact your license. On the other extreme, an adjuster should not attempt to game the system to give away medical or indemnity benefits or to manipulate approval of settlement authority based on untruthful or biased reports for the purpose of making that adjuster's life easy. I'm sure there are many other examples, but those are the ones that kind of came to my mind at first. So to conclude, I guess, with my 4 sections, what I would just say is, believe it or not, judges do have long memories. Your reputation as an adjuster and how you handle your claims, it is noticed by the workers' compensation bench. Your actions are often seen in the responses to petition for benefits, notice of denials, other DWC forms, but more often than not in your deposition when it is taken or during your testimony at a hearing. And with that, I'm going to go ahead and turn it to my fellow jurist to go through E through I believe.
All right. Thank you, Judge Holley. This is Judge Walker coming back to you. I'm going to start with subsection E of the prior rule. And this subsection particularly deals with the public trust and the absolute need for fair and impartial handling. And the 2 words, public trust, I always like to point out in these sessions. Your job as an adjuster particularly is unlike most other jobs in that you are dealing with the public. And the legislature believes that that job is so important that they have assessed basically a number of different rules. And within this subsection, there is a specific requirement that an adjuster, and I think the term is, allow a fair settlement to all parties. And we understand that there are times that you will have a very aggressive employer. They are only wanting you to settle for a small amount of money, and you've been doing this job for a number of years, and you and your supervisor decide and determine that it's worth, frankly, more. I think at this juncture, you have a duty under the code to reach a fair settlement with that injured worker. That will possibly upset your aggressive employer, but at the end of the day, you have to do what's best for the public. And particularly for you as a licensed adjuster, I believe it is imperative to choose to do the right thing. And we're going to talk about that in some degree coming up, but that's just kind of my takeaway from that subsection. The next subsection deals with the duty to handle claims with dispatch and due diligence. And I think everyone understands that many adjusters are under a very large caseload. There's a lot going on at all times with your cases, but the imperative, or at least the code, suggests that you should try to get things done in a timely manner, certainly to the extent you can. Also, the rules dictate that adjusters shall not negotiate or attempt a settlement with a worker if represented by counsel. And guys, we understand this gets tricky at times, particularly if an injured worker calls you and tells you that they have, quote, fired their attorney, unquote, and so they want to go ahead and settle without the attorney. I would caution you about proceeding too far down that highway. without further written documentation. In fact, it wouldn't hurt you to probably call the attorney and confirm that they have been dismissed by their client. It's very tricky, and I know it happens from time to time that adjusters get these phone calls, but I would recommend that you be wary before you move forward to try to settle with a worker that's telling you over the phone that they are now unrepresented. Along these same lines, subsection H states that adjusters cannot advise an injured worker against seeking counsel. And of course, this particularly deals with workers who, at least in the initial stages of litigation, they do not have an attorney. If an injured worker asks you if they should get a lawyer, then I think that the rules are pretty clear that you cannot advise them against that option. And they need to come to that conclusion on their own. It's very important that you address each injured worker fairly and equitably, and importantly, do not ever advise an injured worker not to get an attorney if that seems their intent. And with that said, I believe I'm coming back to Judge Stephenson for her section.
Okay, thank you, Judge Walker. I think the adjuster's life work of handling claims revolves around communications. You have a very complex tripartite relationship. You have your carrier, you have your employer, you have the claimant, and it's such a delicate balancing act that it's no surprise that there's a number of ethics that have arisen about communications. Judge Walker alluded to one of them, the communicating directly with a claimant, and it's thou shalt not communicate directly if they're represented. You're not supposed to do it. But then it becomes very murkier waters when we get to other communications. Subsection I states, an adjuster shall not attempt to negotiate with or obtain any statement from a claimant or a witness at a time that the claimant or witness is or would reasonably be expected to be in shock or serious mental or emotional distress. That's really murky. That's going to be a judgment call on your behalf, because I can think of one example, an on-the-job shooting. The witnesses witnessed the experience, claimant was injured. Everybody is individual as to the reaction to such a traumatic event, and it's going to be a judgment call by you to, when do I reach out, get the statement, and proceed with it. There is one case that deals with this, not a workplace shooting, but a different kind of situation that occurs frequently. It's Fidel Savallo versus Langer Krell Electronics, OJCC number 190307797. Judge Medina Shore had a situation where the claimant was seriously injured in a fall and ended up having to have emergency back surgery. It sounded like he was experiencing foot drop, and the doctor had to get him in there and perform the surgery. In less than 3 weeks, the carrier took recorded statements of the claimant, one of which was he'd just been discharged from the hospital following having surgery. He's under heavy-duty medication, and they outsourced the third statement to an investigator. The investigator refused. The claimant actually asked the investigator, can you call back? Can we do this another time? I have a lot of drugs, and I don't feel like I should be doing it at this point. The investigator said, nope, got to close my file today, and proceeded to take the statement. The other little thing was that the claimant years ago had suffered a stroke that resulted in long-term memory loss, short-term memory loss, I mean. And of course, the third statement, not the first two statements, but the third statement was the one where the claimant forgot to mention prior back claims. The carrier, of course, denied the case, claimed misrepresentation, And the Judge Medina Shore had to go through a very thoughtful analysis of the evidence and all that. And ultimately, she concluded that the claimant didn't intentionally misrepresent his prior back claims. But she expressed concern that the third recorded statement was not postponed upon the claimant's request. And then she went on to say, and this is where she cited to the rule of ethics, while a carrier may outsource some of their adjusting functions, such as recording statements, to outside vendors, this does not release the carrier from satisfying its obligation and the Florida Administrative Code Ethics Rule 69B 220.2103I, the one that we're talking about. So there's got to be some common sense and some judgment calls on this, but that's a situation where we possibly could see it more often in our courtrooms, where there's a situation where claimants asked to postpone a statement, they didn't postpone it, and they denied his case because of misrepresentation. So it's a balancing act for you. Now, J is an adjuster shall not knowingly fail to advise a claimant of the claimant's claim options in accordance with the terms and conditions of the insurance contract. To me, one of the common examples we might see is the one-time change, that they are not advised that they have the right to it. They talk about exercising reasonable promptness in claim communications, and likewise, if a claimant can misrepresent a fact, so can an adjuster. Knowingly misrepresenting relative facts and policy provisions to the claimant can run you afoul of ethics violation. The other common thing that I think we see in our hearing rooms is the failure to advise of rights. This may toll the running of the statute of limitations. So again, it's a matter of making sure that you keep the claimant advised of his rights under the insurance contract. And that leads to the next provision in the ethics about adjuster shall not undertake the adjustment of any claim concerning which the adjuster is not currently competent and knowledgeable as to the terms and conditions of the insurance coverage. In other words, you're supposed to refrain from adjusting a claim if you lack the knowledge of the coverage and specifications of the insured policy. I couldn't find a real clear example, but I could see that this could happen if you're licensed to just in Georgia, but you get a Florida claim. I don't know that that would happen, but that's a kind of factual situation where I could see that, or you just simply got promoted from one department to another, such from property to workers' comp, and you're not quite familiar with workers' compensation. I could see this particular ethic violation coming into play. The other one, the last one that I'm supposed to cover, is L. No person shall, as a company employee, adjuster, or independent adjuster, represent him or herself or any insured independent adjusting firm against any person or entity that the adjuster previously represented as a public adjuster. I think that's a kind of conflict of interest. If he handled the case in another manner, means or form for one company, and you handling it in the opposition on another side, I think that's where a conflict of interest rises. Just kind of like you have a business ownership in a company that Judge Walker talked about. If you handled one side, it probably, if you go and I know example, I saw that before. I've seen this one before. Someone was an adjuster for an insurance company and went to work for a law firm and handled claims. They had the same claim, and that would be a conflict. The person could not then handle that claim within the auspices of the law firm because they previously adjusted it. That to me is what that provision talks about. And now I'm going to hand this off to Judge Walker about the Chapter 626.
Thank you, Judge Stevenson. And I do want to speak very briefly about Chapter 626. I don't want to spend a lot of time on this because, frankly, we've kind of got other cases to discuss at the end that I think will be a little more interesting to you. But I just want to reemphasize the fact that Chapter 626 basically codifies the Code of Ethics for adjusters. And with that said, and that's really our takeaway, there's other aspects of that chapter, and you're welcome to read it if you want to. But I do want to get to some of the 60Q rules that will affect us more on the workers' compensation side. So Judge Holley, I hope I'm not surprising you. I'm sending it to you pretty quickly here. Can you bring us up to date on the 60Q rules?
Absolutely. Thank you, sir. All right. So I guess if the slide for Henry Longfellow could be put up. So this is a slide that kind of resonates dear to my heart. I've had to learn this slide many times, but to read it out loud, it takes less time to do a thing right than it does to explain why you did it wrong. Now, I had to go back and look up Henry Longfellow. I recognize the name, but from my English literature classes, I have to be honest with you, I couldn't remember who it was. So he happens to be one of the most popular American poets in the 19th century. He was an educator. Some of his works included Paul Revere's Ride, the Song of Hiawatha, and Evangeline. He was the first American to translate Dante's Divine Comedy and was one of the fireside poets from New England. He was loved by the common people as well as the academics. And at some point during his life, his fame kind of fell downward as different poets became more loved, I suppose. But anyway, I just kind of wanted to learn a little bit about the man with the quote, and I just thought it was kind of interesting. So anyway, this is a perfect precursor into how selected portions of the 60Q rules should be considered by the adjusters, especially after having covered the early ethics standards. And these are the ones that I kind of pulled out as being most applicable. But competency and expertise, no action prejudicial to the insured, dispatch and due diligence. And I'm sure there are others that would probably apply, but those are the ones that kind of stood out the most. You know, a lot of times, you know, you would have an attorney that would be doing this type of stuff for you, but there are times when there's a delay in getting an attorney involved. And so I'll kind of cover some of that as well. So the easiest and the shortest one is 60Q-6.101. This is maybe 2 sentences at best. In essence, it just says the rules of procedure apply in all workers' compensation proceedings before judges of compensation claims. So my takeaway from this is it's important to be aware that these rules can directly impact your case, or at the very least impact your attorney who is handling your case. And then try to keep it simple. Bad things can happen if these rules are not followed. So let's move on to the next rule, which is a very lengthy rule. I'm not going to read it. It's 60Q-6.114. It concerns discovery, and just kind of a very short highlight of this is that the rule covers depositions. It covers the issuance of subpoenas, the production of documents, and then something a little more obscure is entry on land or other property. So that if you have an employer that has an accident in the workplace that the claimant attorney wants to actually see, there is a provision whereby they can come inspect the premises to see you know, the grounds and the machinery or whatever it may have been involved with. So we don't see that as much, but it certainly is one of those items that's in there. So my first recommendation is really at the discovery stage, you need to have an attorney in play for you. You know, the request to produce is one of the most common discovery techniques that you find in workers' compensation. And even something as seemingly benign as that has certain rules that can come into play that can really be bad for your case. The first being is that if you know, if a response is not filed within 30 days, you waive your rights, your insured's rights and your rights to object to requests for production that may not be entirely appropriate or may not be something that they're entitled to. As well, if objections are not filed within 30 days and the right objections are not filed within 30 days, you may also find that you have waived your right to contest this. Now, an attorney will know when and how to properly object, and especially with regards to attorney-client privilege and or work product. They also know how to have a judge do an in-camera review of work product and attorney-client privilege notes and documents. So, look at this. Once again, that slide kind of comes into play. If you have an attorney that objects properly and does it the right way, then you're likely not going to be trying to explain to the judge why there wasn't an objection or why the judge should, try to find a way to overlook the fact that you've waived your rights during the discovery process. I'd also point out that for depositions, I think I'd already discussed it before, where most of the information that comes out on how you or your predecessor adjusters investigated and adjusted the file, the deposition is where it exists. So I had some recommendations on that, and that includes that you should always investigate and handle claims with the thought process that a deposition could take place, and that you could be asked about what happened and why you did act or why you didn't act, and imagine that a judge will be reading the deposition at some point. Not always the case, but I think if you look at it that way, it may help you with the way you process the claim or adjust the claim. I guess the question you could ask is, how is this going to look to a judge when I'm reviewing a deposition? When he's reviewing a deposition, or she, if I'm accused of an ethics violation, how would this look to the examiner? So I guess another recommendation is documentation. When you have your investigation and claims handling, these actions are critically important. It needs to be clear to you and whoever takes over the file afterward what happened. You've heard the adage that if a tree falls in the woods and no one is there, did it really make a sound? Well, it's similar to documentation. If you don't document, did it really happen? In other words, you could do the most admirable job adjusting a claim, but without documentation, it is more than probable that no one will know and you will not get credit for it. Now, an example that I'm seeing is I'm seeing more and more of these 120-day pay and investigate waiver claims. They're called avoidances, and you'll find them in the pretrial stipulation, usually listed as an avoidance. But as a quick reminder, 120-day rule claims waivers do not just involve the compensability of the action of the claim. It is also being applied to situations where there's body creeping, where new injuries develop long after a claim has been accepted as being compensable, and or for medical procedures or other benefits that are being requested. The statute that you will find this in is Florida Statute 440.20 Parent 4, and I'm not going to read the statute out loud because it's lengthy, and there isn't a lot of time during this presentation to go over that, which could be its own presentation in and of itself. But to give you an example, it's sometimes you'll see a bad back claim, and the injury starts to develop into the knees. The 120-day rule applies initially to the bad back, but it also, once an adjuster is on notice of the knees and a request for treatment of the knees, or the beginning of treatment of the knees, rather, the 120-day clock starts again. So one of my last recommendations on this point would be you need to stay on top of the medical reports when they come in, document your review, your analysis, your actions, so that you can prevent from waiving the right to contest these new body parts or medical procedures. If you do deny a medical benefit, explain in detail in your notes why you decided to do that. Also notate how the denial was expressed or provided to the claimant as proof that the claimant had been provided that, or to the doctor. And if you're reviewing past medical records that were not received until well after the records were generated, document when you received those records so that it's clear in your notes as to when that time frame might have begun. So that's just one example, I guess, of how I think that the ethical standards do apply, at least to that 60Q rule, and I'm sure there's many, many others. So next, let's talk about 60Q-6.113, pretrial procedures. This is also a time when an attorney is really needed. First of all, it's mandatory that the uniform pretrial stipulation is filed, and subsection 4 states that unless good cause is shown, a party's failure to cooperate in the preparation and filing of their portion of the joint pretrial stipulation shall result in the imposition of appropriate sanctions, including but not limited to the striking of claims and or defenses. So the first point out of that is I don't think you want to have to explain or have your attorney explain why there was not a timely filing of the pretrial stipulation. And second, by the language contained in that subsection 4, it indicates that there should be cooperation between the adjuster and perhaps even the employer representative and the attorney in forming your side of the pretrial stipulation. You know, one of the things I guess that I've come to see is that the uniform pretrial stipulation has become a pretty dangerous pleading. And one that attorneys cannot be careless with, and through the attorneys, obviously, you as the adjuster. So any ripe defenses that are not listed in the pretrial stipulation are waived, except for good cause. And good cause typically requires that the defense was reasonably not known about at the time that the pretrial was completed. So, you know, this can be a problem, I guess, for adjusters and attorneys if they're not able to read the claim notes, especially problematic if surveillance has been started and the attorney is not aware of it. So again, this is part of the communication that is very vital between an attorney and his adjuster, and vice versa. You know, the last sentence that was stated in the rule kind of explains what good cause isn't. It says the failure to diligently seek and obtain discovery standing alone does not constitute good cause for failure to timely raise a claim or defense. So I guess the practice point that I took from that is that it would be a good practice, it would be a good idea to talk to your attorney about the potential defenses in your case, especially if there's surveillance or misrepresentation before the pretrial is filed. Now, there are times when the stuff or material or information takes place after the pretrial, and those are those are usually easier to establish good cause on, but it still requires your attorney to try to explain to the judge why it should be included. All right, so kind of speeding through, there is another portion of this, and I'd like to say that there are other places in the Florida statutes and or the 60Q rules where there is discussion of sanctions, but this is primarily the main one under 60Q-6.125, and this provides that a judge may impose one or more of the following sanctions. So striking claims, striking petitions, defenses, or pleadings, the imposition of cost or attorney's fees, or such other sanctions as a judge may deem appropriate when there's a failure to comply with the provisions of the 60Q rules or any order of the judge. Additionally, there's a subsection 2 that states in part that by filing a pleading or other document or presenting an argument before the judge at a hearing, an attorney or unrepresented party, which could be an adjuster, I guess, is certifying to the best of that person's knowledge, information, and belief formed after inquiry, reasonable under the circumstances, that the information contained in is not for an improper purpose, for example, to harass or to cause unnecessary delay or needless increase in the cost of litigation. It also applies, in the sense of that claims, defenses, and other legal contentions are warranted by existing law, that they're supported by evidentiary evidence and support, or that after a reasonable opportunity, it's believed that it's likely that it's going to be supported by further investigation or discovery. And then last but not least, that any denials of factual contentions are true and warranted on the evidence. So under those circumstances, it would not be surprising if you have an attorney who says to you, I can't sign my name to that document because he or she does not want to incur potential sanctions to being filed against him and against your insured and or your company. So in any event, I see a lot of these arguments for sanctions with these motions to enforce, where a stipulation has been reached either at mediation or as part of an agreement to call off a trial on medical benefits, sometimes indemnity benefits, penalties and interest, things of that nature. And so that's probably more commonly where you'll see some of these items. Now, I do have a quick war story. It was a first for me, and it was relatively recent ago. But I had a case where a claimant attorney filed an action for sanctions against the employer carrier on the theory that the adjuster's denial of a medical benefit was frivolous, and it had been done without any actual evidence. Interestingly enough, the claimant attorney had not filed a petition for benefits and had done so on purpose in an effort to constrain the adjuster's ability to conduct depositions without paying attorney's fees. It was a very strategic move on the claimant attorney's part to limit to the adjuster's options from that standpoint. So, but anyway, we did have an evidentiary hearing on it, and the adjuster was required to testify. And I believe the nurse case manager also had to testify as well, if my memory serves correct. But anyway, long story short, the adjuster, it was found that the adjuster had properly documented her file about how she investigated causation and or the need for medical benefit and what steps she took to go about trying to adjust the claim. She also provided adequate documentation about the lack of cooperation by the claimant, which was also something for consideration. On the basis above, I guess I denied the motion and the sanctions were not awarded, but you can see where this was a situation where if the adjuster had not done anything as part of an investigation, this could have been a much different result. And the attorney had probably had a couple of 100 hours in the case. So it could have been quite an expensive situation. Anyway, I know it's unique, but I think this just is one example of how documentation and goods claims handling can prevent unfavorable sanctions on your files. So with that, I guess I will switch it over to my fellow jurist to handle section 440.105.
I do appreciate it. Thank you, Judge Holley. Again, just want to speak very briefly about section 440.105. This, of course, is the fraud reporting requirement. This has been in the statute for a number of years, and it basically states that all adjusters are required to report fraudulent acts to the Division of Workers' Compensation. Fraud, emphasis on the word shall. It is a mandatory statutory provision. At that point, the division then completes what they call an independent examination of the allegations. And if there are sufficient grounds to warrant a referral, then a referral is made to the state attorney's office. As you might imagine, this is relatively rare. I don't know of any examples off the top of my head that this has occurred. One thing I do want to point out before I turn it over to Judge Stevenson is that section 440.105 does leave an out, and that is if an adjuster reports what he or she believes is fraudulent behavior to the division. If they do so in good faith, then the particular term is without malice, then there will be no civil liability for slander or libel or anything like that. And for instance, if an adjuster became angry because somebody had stolen their lunch from the break room and then filed a claim, that might be a different story, but as long as there's some type of good faith basis to the report, it will be no civil liability reoccurring. So with that, Judge Stevenson, I'm going to turn it back to you. We are around at the 15-minute mark. So if you could, take it from
Okay, thank you. I'm going to be referring to a slide with a quote by Earl Warren for first-degree misdemeanors. The quote is, "In civilized life, law floats in the sea of ethics." In other words, there's a foundation of ethical values for the law. There are legal consequences for unethical behavior, and Florida Statute section 440.1052 consolidates those prohibited activities, whether the activities are done by the injured worker, the employer, the insurance carrier, or attorneys, in fact. And subsection 2 talks, I'm sure everybody kind of glosses by this, but whoever violates any provision of this subsection commits a misdemeanor of the first degree. What are the punishments for misdemeanor of first degree? They can be up to a fine. They can be a fine and or jail time up to 1 year jail time if you violate these provisions. So this isn't anything to ignore. This section starts out with some unlawful activities by the employer. I think I'll skip over the first one, but the second one is to discharge or refuse to hire an employee or job applicant because the employee or applicant has filed a claim for benefits under this chapter. This is retaliatory discharge. If the underlying reason for the discharge is the employee's previous workers' compensation claims, that's contrary to public policy. And if it's proven that an employer has done that, either refused to hire someone with a prior workers' compensation claim or discharged them because of it, that could be fine or jail time under this provision. The next one I like to focus on a little bit is what I call the whistleblower policy. As Judge Walker was talking, if the adjuster reports something, if the carrier that the adjuster is working for discharges, disciplines, or take any other adverse personnel action against any employee for disclosing the information to the department or any law enforcement agency relating to any violation or suspected violation of the provisions of this chapter, that's a protection for someone who does report fraud. I call it the whistleblower thing, and there's a lot of movies out there about whistleblowers, and I won't dwell on it, but there's one of my favorites is The Firm, 1993 movie where a young lawyer joins the prestigious law firm, only find out that the law firm has all these bad clients and does things like murder off partners who threaten to blow the whistle on them, but the FBI comes calling and has the attorney become caught in a rock and a hard place to report on the behavior of the law firm. So they have set up statute provisions to help protect people, whether working for employer, carrier, or someone else that reports on any kind of fraudulent activity. There's that provision that protects you. The next thing that is insurance fraud. There's a Bureau of Workers' Compensation fraud that's dedicated to the investigation and prosecution of fraud cases. As we can imagine, temptation can affect anybody involved in the system. And if a person succumbs, again, can be subject to arrest, fines, even jail. For example, employers who misclassify employees, submit understated payroll records, alter certificates of coverage. Physicians, if they help or urge someone to commit fraud, misleading reports and bills, they can be part of insurance fraud. Attorneys are not absolved if they help or urge an injured worker to collect benefits fraudulently. That's a third-degree misdemeanor. Unlawfully soliciting clients in hospitals, courthouses, and other public institutions is also no-no. In addition to jail and fines, an attorney can be subject to disbarment and bar sanctions. And this one I think I'll note because I'm not sure people remember this one all the time. Attorneys can commit a first-degree misdemeanor, fine, 1 year jail time by failing to have a fee approved by a JCC. That's Florida Statute 440-105-3B. And I think, because movies are one of my things, I think a movie that puts together perfectly litigation, insurance fraud, and courtroom time is The Rainmaker, a 1997 movie where a new attorney works for a shady ambulance chasing a lawyer to earn his fee. He has a hunt for potential clients at a local hospital. He meets less than an ethical former insurance assessor turned paralegal. When the insurance company Adopt Black refuses her dying son coverage, the two men team up on a case of bad faith to fight the corrupt corporation. I won't get, even though it's 1997, I think I can give away that they actually win, but the insurance company goes bankrupt, so no punitive damages are recovered in that one. So again, I'm going to skip over hospital solicitation because that goes more toward attorney. The last one of importance is the fraud statement under Florida section 440.1057. An injured employee or other party making a claim under this statute, the petition for benefits, shall provide his or her personal signature attesting that she has reviewed, understands, and acknowledges this filing statement. Any person who knowingly and with intent to injure, defraud, or receive any employer, employee, insurance company, or self-insured program files a statement of claim containing false or misleading information commits insurance fraud. If an employee doesn't sign the petition for benefits, that attestation clause, the carrier can suspend benefits until the signature is obtained. However, if the petition for benefits doesn't have the attestation clause signed, doesn't divest us as JCCs of jurisdiction of that petition, it can't be dismissed. Under Rule 60Q 6.1071 combined with Florida Statute 440.192 2 for 4, a dismissal of petition goes to certain information that's required by the statute. And those statute sections do not mandate a petition to include the fraud statement or signature of the claimant. So you may be able to suspend benefits, but the petition can proceed before us on the other claims. With that, I'm going to turn it over to the practical application of ethical requirements. I think that's you, Judge Walker.
Actually, that is Judge Holley. And guys, here's the deal. It looks like we've got about 5 minutes left. And Judge Holley, if you want to, I know you guys have some cases you want to talk about. We just don't have much time left. And Judge Holley, if you maybe want to say a word or two about your cases, and Judge Stevenson, you can do the same, and then we can go ahead and close. Judge Holley?
Okay, very good. All right, well, I'll skip down to that real quick, and then let's see. So there's 2 cases that I was asked to brief in a sense that interestingly enough, they have kind of similar fact patterns in some ways, but in others, they're quite distinguished and they have different results. So the Marshall versus Amerzis Incorporated case, 943 Southern 2nd 276, it involves a managed care systems administrator being sued under a theory or doctrine in tort law that makes a master liable for the wrongs of a servant, in an ancient way of saying it. Another way of trying to put this theory forth is that an employer, in this case, the administrator company, can be held legally responsible for a wrong committed by an employee or agent if it was committed within the scope of employment or agency. In this case, however, the insurance company's agent, a nurse case manager, was alleged to have committed negligence, defamation, intentional infliction of emotional distress, and other claims resulting from the nurse case manager's communication of statements the claimant had made to her regarding his potentially destructive nature and his ability to make bombs and silencers. So this action was filed in the local circuit court in the Miami area. The defendant, the company, filed a motion to dismiss the complaint. The local circuit judge dismissed the claimant's or the plaintiff's complaint with prejudice. It was appealed to the 3rd DCA, where it was ultimately affirmed or upheld. And in ruling, the 3rd DCA indicated that the nurse case manager's alleged misconduct did not rise to the level of a separate and independent tort, and that the nurse case manager's alleged misconduct was not so outrageous in character and extreme in degree as to support a claim for intentional infliction of emotional distress. So what was the actual conduct? So you had a claimant who was frustrated with the handling of his claim. Apparently, it had many problems obtaining benefits and requested information regarding the grievance process. The claimant was also informed, the nurse case manager that he needed to talk out his anger resulting from the way the case was being handled, as he was concerned that he might become destructive if his anger got out of hand. When asked what he meant by destructive, he responded, "I know how to make bombs and silencers. How's that for destructive?" Well, the nurse case manager then turned around and reported to her supervisor that the claimant was pissed and was making bombs and silencers. This report was forwarded up the chain until a formal police investigation was commenced on the matter. The nurse case manager also sent the claims adjuster an email requesting help with the claimant, stating that the claimant had informed her he was at home building bombs. Obviously, both of those statements were different than what the claimant said, but I don't think it was totally out of concern. I think I would have been concerned under the circumstances. So fortunately for the administrator company defendant, Florida workers' compensation law provides statutory immunity for claims or grievances arising out of a workers' compensation claim. However, the statutory immunity has its limits. So if the District Court of Appeal had deemed the conduct alleged by the nurse case to rise to a level tantamount of intentional tortious conduct, this immunity would not have been effective. and if the nurse case manager's conduct had been deemed to be a type of conduct that is so outrageous in character and extreme in degree to go beyond the bounds of decency and be deemed utterly intolerable in a civilized society, again, this immunity would not have been effective. My takeaway from this is this was probably a close call in some ways, and just a few additional facts could have made a difference in the outcome. And we'll see in the next case where there was a different outcome. So in Liberty Mutual
Judge
versus,
Holley,
yes.
Judge Holley, we are almost out of time, and I hate to cut you off, but I do want Judge Stevenson to have an opportunity to maybe just give us about a 60-second takeaway of any of the cases that you've reviewed.
Okay, I'll do Santiago versus Boyd's Transport. That's a case where, again, the claimant was just simply frustrated and brought this claim for intentional infliction. The carrier had failed to respond to 10 petitions for benefits. It had denied or delayed paying him for monetary benefits. It hired adjusters from out of state to handle his Florida claim. The carrier challenged medical necessity of various benefits, didn't comply with an OJC order, and it provided input concerning his treatment. The Middle District basically said, no, this isn't the type of outrageous conduct that we're looking for intentional infliction of mental distress. It's simply delay in payments, just the usual kind of stuff that doesn't rise to that level. So it's not quite the level that, those kinds of things aren't probably going to be quite the level that we're looking for intentional infliction of emotional distress.
Thank you, Judge Stevenson, and thank you, Judge Holley. I do apologize to both of you. I think we were going really good there. We kind of had to cut it off because we are at the 60-minute mark. In closing, and again, thank you both for participating. I do want to leave everyone with a quote that we came up with from Justice Potter Stewart, formerly of the United States Supreme Court, and Justice Stewart stated as follows: ethics is knowing the difference between what you have a right to do and what is right to do. And I think Justice Potter Stewart kind of succinctly brought everything together that we talked about here this afternoon. And again, I do appreciate everyone's time. Certainly, I want to thank my panelists who gave of their time, and we worked through a couple of technical issues this past week, and I thank you both. And with that, everyone, we're going to go ahead and conclude. Thank you for your time.
Thank you, everyone.
Thank you.
Thank you, everyone.